Hello, my name is David, an artificial intelligence assistant of thelegalpsychology.com. I am here to navigate you through today's topic and psych you up. So please pick my brain. Let me introduce you to Linda. Linda is an intelligent and outspoken person who majored in philosophy. She was deeply concerned with discrimination and social justice issues as a student. Now let me ask you this. Which option do you think is more probable? Option 1 is that Linda is a bank teller. Option 2 is that Linda is not only a bank teller but also a feminist. Now, if you have chosen option 1, good job buddy, you are most probably a litigation god. So keep up the excellent work, you have nothing to do here. However, if you are a lawyer and have chosen option 2, then you've just fallen prey to the infamous conjunction fallacy. This means that you are at the right place, and this video is definitely for you. Conjunction fallacy is a well-known judgmental bias that shows that people erroneously believe that events described in more detail are more probable than those that are described in less detail. This phenomenon originates from Amos Tversky and Daniel Kahneman. Their most famous experiments presented Linda, the hypothetical person you already know. They asked their participants to rank order several statements about Linda regarding how likely they considered them to be. Tversky and Kahneman reported results indicating that most participants chose option 2 just like you probably did. So don't be too hard on yourself. You are just as reckless as most people. For now, you most likely already see the problem. The probability of two events occurring together or in conjunction is always less than or equal to the probability of either one occurring alone. Surprisingly, the conjunction effect has been found in expert attorneys and judges too. And there is strong scientific evidence that lawyers are highly susceptible to this bias in judging the likelihood of potential trial outcomes. In a series of studies, Fox and Burke recruited a sample of California attorneys with varied civil practices and asked them to consider the antitrust case U.S. versus Microsoft. Half of the participants were asked to judge the probability of the hypotheses that the case would go directly to the Supreme Court. The remaining attorneys were asked to judge the probability of the hypotheses that the case would go directly to the Supreme Court and be affirmed, reversed, or modified. Suppose you get that far with this video. You already know that judged probability of the second hypothesis that the case would go directly to the Supreme Court and be affirmed, reversed, or modified is the same as the judged probability of the first hypothesis that the case would go directly to the Supreme Court, because the latter hypothesis merely elaborates the former. Nevertheless, the latter elaborated version received a higher median judged probability than the unelaborated version. This result proves that lawyers judge an event's probability to be higher when it is unpacked into an explicit disjunction of constituent events. It is a piece of alerting news because judged probabilities are essential as they serve as a currency of communication between lawyers and their clients. A lawyer's prediction of the outcome of a trial plays a crucial role in many vital litigants' decisions, such as accepting or rejecting a settlement offer. The takeaway lesson is that lawyers must expunge the conjunction fallacy from their judgments to compensate for the potential bias when forecasting outcomes. Thank you for your attention. We hope that our video has helped you to make a step towards outsmarting your own biases. Please don't forget to subscribe and follow our blog thelegalpsychology.com.